This is the American Law Journal.
Darlene Jesperson worked as a bartender at Harrah's Casino for 20 years. She always got good reviews. Initially, she wore makeup on the job, but then stopped. At first, Harrah's didn't mind, but then they established a personal best grooming policy requiring women and forbidding men from wearing makeup. Jesperson didn't put the makeup back on. She lost her job and filed a sex discrimination suit. Representing the employee's position is Philadelphia attorney Alice Ballard. For the employer, attorney Anthony Harrah of Blank Rome. Now, this is an actual case decided by a high federal court. The central question is, does an employer have the right to tell an employee that she has to wear makeup on the job? You're the judge, you decide.
If you want to present yourself to the outside world and show them who you really are, what's more important, your face or the back of your neck? And if you've been a fabulous bartender at Harrah's for 20 years and they tell you you have to change your appearance, which is harder to change? Which is a bigger burden on you to change, your face or the back of your neck? You say, what difference does it make? You know, women have to wear makeup, men have to cut their hair, no big deal. We say it is a big deal. It's a big difference, and it's also an unlawful difference for two reasons. An employer is not allowed to treat women differently based on a stereotype, a sexual stereotype. And this makeup rule is based on the stereotype that women need makeup to look good. The second reason is the law says you can't have personal rules for women and men that burden the women more than the men. And telling a woman she has to change her face, either by wearing makeup or maybe even telling her she can't wear makeup anymore, burdens that woman a lot more than telling a man he has to get a haircut. God gave you your face. She did not give you your hairstyle. And changing your face is a very different elemental thing to who you are than changing your hairstyle. Darlene Jesperson wanted to put her best face forward. She wanted to show her customers that she's accommodating, that she's competent, that she has confidence in her work, and they're going to have a good time when she's bartending for them. And she wants to do it without makeup. And after 20 years, she should be able to.
Alice, I know that you want to make this case about stereotyping, but it's not about stereotyping. This is about a program, the personal best program that Harrah's put out, that creates a uniform standard applying to males and females equally of excellence for guest services, because that's the business. And your client claims that discriminates against her on the basis of gender. Well, it doesn't. She's making the claim because she doesn't want to do what other women are willing to do under that policy. And she makes this claim even though she was given an opportunity, if she wanted, to do a different job that didn't have those requirements. And what are the requirements? They're not stereotype. They are content-driven. There are rules that apply to men. Men have to do certain things, like they can't have ponytails. They have to have their hair cut short. Those are rules that apply to men. Each person who works there, male or female, has to have a body that is well-toned. It's an appearance-based program. And you know well that the law is very clear on this, that appearance is not an immutable characteristic like someone's sex or someone's race. It can be changed, and if it can be changed, it's not protected by the law. You can make up rules so long as they have a valid business reason, and so long as they don't create an unequal burden upon men and women. And in fact, in this case, there is no evidence that's been presented to the court that suggests that the burden on this particular individual to wear makeup was greater than the burden on men to comply with the rules that were imposed upon them.
Anthony.
And for that reason, clearly you lose.
Anthony, you know the law in this circuit is that a personal rule that applies differently to women and men, even though it's about an immutable, not immutable characteristic, can be sexually discriminatory. You know that it's unlawful to say women have to wear contacts while men can wear glasses. You know that. That's what the law says, and that's what we're working with here. This is the same kind of case. And the burden on women has nothing to do with whether they have to go out and buy makeup. and put it on, spend 10 minutes doing that. That is not the burden. The burden is the deep personal burden on them is you have to change your face. You have to improve your face. And some women, most women, will go along with that. Most women are more comfortable with their makeup on, and they feel their faces improved when they have it on. But not all women. And the law says that it's here to protect every woman, not most women. And Darlene Jesperson is a darn good bartender, and she's entitled to the same protection
But with due
as
respect,
everyone
Alice,
else.
I agree with you that the law says if there's an unequal burden, so that if you're imposing, for instance, a different weight requirement upon a female than a man because of the body build, that would be a violation of the law. But that's not what we're talking about. This was a policy that was narrowly tailored, defined, to allow the company to present a certain image, which it wants to do for business. It's a legitimate policy for a company to say, we have rules, they apply to both sexes, they're not going to be identical because the sexes are different, but the burdens are relatively equal.
Well, the whole question of appearance, it's not just that they have the same business standard. Their standard is appealing to the eye. It isn't Harrah has a policy that all women have to wear makeup because we want all women to be made up. It's all women have to wear makeup because we want them to be appealing to the eye. Now, I can tell you something. That's a stupid rule. And telling women they have to wear foundation, blush, lipstick, and mascara so that they will be more appealing to the eye is really dumb. If you let women decide how to make themselves look more appealing to the eye, they're going to do a better job of it than management telling them they have to wear foundation, blush, lipstick, and mascara.
Whether it's a good idea or a bad idea is not the issue. The issue is whether it's unlawful. And we can debate whether it's a good policy or not. But the underlying point is that an employer can set some policies on appearance. And if they don't have an undue burden, then there's nothing wrong with it. And there are limits to the law. There's at some point where the law needs to stop interfering with the rights of people to decide how they want to either run their business or individually to appear.
But there's two ways the law is going to look at this. There are two tests it has to pass. Not only, number one, does it impose an undue burden, but even if it doesn't, number two, is it based on a sexual stereotype or not? And the stereotype that all women need makeup to be so that their appearance is appealing to the eye is a sexual stereotype. It's based on an idea in our society that women are supposed to make up to improve their appearance.
That's a completely false logic, because if you extend that argument, this is the result, and I think anyone would agree that this is a silly result. If you take that argument, then a man that doesn't want to comply with this policy and wants to wear makeup should be entitled to wear makeup. Because if you say you can't wear makeup, you're being accused of the same stereotyping. That is, you don't think males should wear makeup. And that's not the point. The point is here, you want people to come in to the business, to the casino. You want them to use the guest services. You want them to have people that have an appearance that is polished and well-groomed. Polished and well-groomed. That was the basis for this policy. It's not a stereotype.
Well, remember that Darlene Jesperson got fabulous reviews over 20 years from the customers, not just from her own management, who said she was doing a great job, but for the customers who said, yeah, she's a good bartender. I liked having her. I'd like to come back. She's obviously got, she is living proof of the fact that this stereotype doesn't necessarily apply to every woman. Not every woman's face is going to be improved by the application of makeup. Not every woman's appearance, that's what they're trying to get, appearance is going to be improved by the application of makeup. And not only that, getting back to my point about the face is so important to us. The face is what you show to the world. And these men are allowed to have beards on their face. There's nothing in this rule that says they have to change their face, the basic element of their face, in order to be able to work at Harrah's.
That's not true. You have to have a body that's well-toned.
Everybody has to have a body that's well-toned. That's across the board. Hey, rules like that, if it's the same for men and women, that's fine.
How about a man that has difficulty with his weight? Isn't that
same
a burden?
for women? Any rule that's across the board, no matter how lousy a rule it is, that's, the law doesn't care. What the law cares about is two things. If it's a different rule, does it burden the women more than the men, or is it based on a sexual stereotype?
If you take that point, the logic is then the men can wear makeup, right?
I don't know about the logic. The law isn't about logic. The law is about experience. You show me the case where the man is suing Harrah's because he worked for 20 years as a great bartender, then he started wearing makeup, and he got fired.
Harrah's wasn't saying this
Where is this man?
Harrah's wasn't saying this wasn't a good employee. They're saying she's a great employee, which is why when she said she didn't want to wear makeup, they said, okay, apply for another job where that rule doesn't apply. She chose not to do that.
Yeah, she doesn't
which is
want
an
to
irony
bus
of this
tables.
case.
She doesn't want to, there are lots of jobs at Harrah's where you don't have to wear makeup. This is her job. This is what she's good at.
The real point is that for her to bring the case, she had to come forward with real evidence that this imposed an undue burden. And she didn't do that. And your point about appearance and makeup doesn't make sense because it's not gender discrimination, because what is different about her is the way she wanted to appear versus other women.
The court below really got this wrong about the undue burden. They looked at undue burden as how much money you have to spend to put on makeup and how much time you have to spend putting on makeup. That is not the point. The point is, what does it do to you as an employee to have to change your face, whether it's putting on makeup or taking off makeup? And Anthony, the point you made, why can't Harrah's make her behave like all the other women? There you have it. Why can't we apply our sexual stereotype to her? You start talking about her having to behave like other women, I win the case, because now you're talking stereotypes.
We are not talking stereotypes. We're talking about a uniform policy that applied to men and women, that had components for each, that is nothing to do with anyone's gender. And in fact, this case is about a woman that decided she personally wanted to exempt herself from the policy that applied uniformly to anyone else. Harrah's legitimately thought that having the right image for its business, and they're in the hospitality business, was the right thing to do. And the law requires your client to come forward with evidence that not she individually, but that women as a class, through this policy that applied to everybody, were put to a greater burden. She hasn't done so. There's no evidence to that effect. And this ultimately means she doesn't have a case. This is a uniform policy, and it's nothing to do with gender.
So how did you decide? This case is from the Ninth Circuit, one step below the U.S. Supreme Court. This court noted that Harrah's personal best policy not only addressed makeup issues, it also required women to tease, curl, or style their hair every day. Men had to keep their hair short. So the court said employers can have different appearance standards for men and women as long as the standards apply an equal burden on both sexes. Verdict for the employer, Harrah's. The case has not been taken up by the U.S. Supreme Court, but the Ninth Circuit will revisit the issue. Well, a couple of years ago, the BBC put together a documentary which documented many women's trials and tribulations. Here's one woman's account in her challenge up against the glass ceiling.
Our budgets, the directors will be meeting Monday to go over our initial capital budget request. I think you have to be a little thick-skinned. If a woman has to do anything different than a man, she may have to be a little thicker-skinned and let a few things roll off her back and not take them personally.
Hi, Mike.
Hey, Bill, how you doing?
Is this one of the booms that we're doing the new dielectric testing on?
Yes, ma'am.
I'm Assistant Executive Vice President, which is the second position in this company. I like the business aspects of making the business decisions. I like working with the people in the various areas. I think the part I like about my job is I don't do the same thing every day.
What risks would you say you had taken in your career in order to get yourself to this position?
The first risk I took was taking a high-profile job in a non-traditional women's position, and that, believe it or not, was being a prosecutor in a rather rural community where I had office support, but there were no other attorneys or prosecutors. And each day, no matter what the case, I had to prosecute, whether it be the fender bender or the murder. You're in a very high-profile job, and I think that they were probably expecting you to fail.
Have you had to make any sacrifices to be where you are today?
I would say I've sacrificed a personal life, but it's not necessary. A woman can do it all, and she can have a personal life. But I have elected to work longer hours or maybe go to some of the off-premises functions, and those things have taken their toll probably on a personal life.
You don't seem too unhappy.
No, I'm not. I didn't say I don't have a personal life, but I am single at this time. I have been married. I'm single now, and I'm enjoying it. But I could see in the marriage that a lot of things, a lot of complications there, and I'm enjoying being single.
How do you do your job as a woman that is different from a man, if at all?
If anything, I believe it's my relationship with subordinates and peers. I have found that I can probably get them to work together, and I can resolve conflicts among them a little bit easier than the men. But I think you have to exercise authority. You have to make a decision. There's no question about that.
Interesting words. Nancy, you've got to exercise authority. You have to make a decision. There's no question about that. Different rules for men, for women, still today?
I think the rules may be the same. It's just how you execute them. Life is more difficult for women many times in the workplace. There's no doubt about it.
And Deborah, in all the work that you're doing, you know that Nancy Easold filed a lawsuit against a law firm going back, and it is 15 years ago, and it made headlines. We haven't seen much of that since. We've seen a lot of women file lawsuits, class action lawsuits, individual lawsuits. Is it any better today than it was 2 decades ago when, again, right around the same time that Nancy decided she wasn't being promoted to partner with a major law firm and it was time to take action?
Well, certainly the statistics that we get from the Department of Labor with regard to pay show that the pay equity is much, much better than it was. In 1970, women in this country were paid 59 cents on the dollar for every dollar that a man made. Today, that number is up into the 80s. For women who are 16 to 24, there's very little difference in pay. Across the board, all working women and all working men of those ages between men and women, 16 to 24. Interestingly enough, the disparity begins at age 35. Women who are 35 and older make 3/4 of what a man of the same age makes. So I think that we've made great strides in terms of pay equity. What we're not seeing are the numbers at the top.
Nancy, I think you told me that women are, for example, in the legal field, women are getting to partner much more quickly and in greater numbers than they did 15 years ago when you filed suit, but that it's not the whole ball of wax.
Yeah, and I'm not sure I would say much more quickly. Frankly, I think it's really going at a snail's pace when you consider where we are in the year 2006, when you consider when I graduated from law school, which is a couple of decades ago, virtually 50% of my class was women. So at that time, the law firms were saying, well, there aren't enough women in the pool to have that many partners. We're way beyond that at this point. Women are still not making partner anywhere near in the numbers that men are. And when women make partner, what's deceiving is often they are not made equity partners. And in the law firm milieu, that's what matters. Do you get a piece of the pie, or are you just a salaried employee with the title partner?
Let's take a quick look at some of our statistics, and it's amazing because depending on who you talk to, they differ wildly. Women earn 68 to 88% of what men earn. They hold 50% of all mid-level management and professional positions, yet only 2% are CEOs. Of the Fortune 500 top earners, about 8% are women, about 1.5% of the top earners in the Fortune 1000. It has more than doubled women starting their own business since 1997, and the glass ceiling issue is important not just here in America. Actually, America, compared to the rest of the world, is pretty good as far as the numbers go, which may also be a statement of how poorly the rest of the world is doing, but there is pending legislation in Norway and England. So we're going to finally give the guys a chance to chime in here. Tony, things seemingly have improved somewhat, but we've got a long way to go.
Well, I think that's true to a degree, Christopher, but there are a couple of things. I think if you look at the statistics, you'll see that the number of women in senior management positions over the last 10 years has gone up, I think, according to the EEOC, by at least about 7%. I think the EEOC 2 years ago came out with a review of its glass ceiling analysis and said that, to quote, many women have broken through the glass ceiling and many others are chipping holes in it. So we still have a problem, but I think that strides have been made. But there's one thing that I'd like to say at the outset. If you step back a minute and look at some other statistics, you will see, for instance, that on average, men in the workforce work approximately 21, I think the statistics are 47 hours a year versus women at 1675. On average, men are have about 16 years of experience versus women at 12, and 67% of women are in part-time positions, as opposed to just a very small percent of men.
So those are factored into the statistics?
So I think that there are a lot of social reasons why the advance has not been as dramatic as one would like.
But are you saying that the statistics are skewed because you're factoring in women who are not working full time, women who are maybe taking FMLA leave? What are we talking about here?
Well, it's a number of factors. There's been a lot of press recently. Fortune magazine ran an article, New York Times magazine ran an article of what was being termed, and all of the people who have been writing the articles are women, the opt-out revolution. And there's clearly something going on where a number of women are making decisions not to have the type of traditional corporate ladder career that we have begun to use as a yardstick for success. I'm not sure it should be a yardstick for success.
I think there's a huge gap between the laws that have been passed and the courts that are out there to enforce the laws when cases are brought and what actually happens in corporate America. I think there is a huge gap. We see policies, they're printed, they're posted in the cafeteria, they're sent out to the employees, and they don't mean anything. They're there because some attorney went into the corporation and said, you know, we have these laws and this is what you should do to comply. Clearly, some corporations do and do a good job. But there is an inordinate, huge number of employers who really pay very little attention. And what's amazing is that I think a lot of people think it is in their best interest to do so. It is in their best interest to have a diverse workforce. There are women out there and there are minorities out there that you can do business with if you have women and minorities in the corporation. But it is not a case where the laws have been passed and corporations are out there implementing the intent. It's not, to a large degree, not happening.
I just think it's a huge oversimplification of this issue to attribute all of the problems to discrimination in the workplace. For example, there's only 14% of Congress is women. Is that because the voters discriminate against women? Or is it because there's some barriers to women going into public service, running for office, and those kind of things? 50% approximately of the medical students are women, yet a much smaller percentage of those people end up being doctors in hospitals. So why is that? There are a number of different issues, social issues, that I think need to be examined in this debate. And it's not, there may be certain employers that discriminate. I would submit that most employers try to do the right thing, but there are a lot of issues beyond discrimination.
Folks, we want to take a quick phone call here from Betty Spence, who is the Executive Director of the National Association of Female Executives. And I know that, Betty, you were also with Catalyst for a number of years. Essentially, your organization is there to make certain that women have a fair shake at the workplace.
It's our role to advocate for women, and I was very interested in Tony's having brought up the fact that women are still such a low percentage in Washington, they are 14% of the Senate and 15% of the House.
Yeah, well, he got that right, yes,
And
for sure.
it is exemplary of the kind of systemic discrimination which exists throughout the entire country. It's not just in the corporate culture that we have this issue to deal with. It is in politics, and it is everywhere you go that we have stereotypes that we continue to come up against that affect our wages, that affect our advancement, and that affect our success.
But Dr. Spence, do you give no credence to some of the articles that have been written recently about women making choices to have different career paths, to really sort of opt out in many ways from the traditional paths of success, which doesn't mean that those aren't great paths to take?
I'm sure that there are women who would prefer to take other paths, just as there are men who will take other paths. But the fact is that something like the gender wage gap, if you look at women who never leave the workplace, they work at the same pace for as many years and have the same experience as men, and they are still experiencing a 12% wage gap that cannot be explained by union status, by child raising, by industry differences, or by occupation.
Also, the article in the Times about these voluntary moves out of the workforce is anecdotal. It's just, they interviewed some people. I don't think that I think because the Times writes one article, I don't think that that's a trend, and
right,
I don't think that we've
women
seen
who dropped
that
out of law of their law practices.
But that doesn't mean that they've stopped working, that they've dropped out of the workforce, they've changed careers. But I'm sorry, I don't think we have any evidence that that's a trend.
I agree. Women are not dropping out.
Dr. Spence, one more question for you before our window closes here, and that is this. With changes on the Supreme Court, changes in the federal judiciary, are you confident or are you concerned about the trends we're seeing and how these courts will handle gender discrimination over the next 5 to 10 years?
Well, I'm very concerned, of course, about what's going to be happening. As it is right now, the EEOC receives about 1,200 complaints a year filed under the Equal Pay Act, for example, and they only have the resources to litigate 400 cases a year. That's not going to get better. We have now got a Chief Justice who, in the 1980s, wrote that he did not believe that there was a gender gap. He called it the purported or the so-called gender pay gap. I am extremely disheartened by what is happening right now and not thinking that the courts are going to be a remedy at all in the future for women.
Anyone else want to touch that hot potato?
Yeah, I do.
Go ahead, Deborah.
I don't know what the courts are going to be like in the future. No one can is that prescient. I have concerns as well. I share your concerns. But I do know that we've had a lot of judge-made law in this area that's awfully good. Judge Posner in the Seventh Circuit last year issued a wonderful opinion for women who go back to work after having given birth, where a woman went out on maternity leave, came back, and then felt that she was being discriminated against because she had children and that people weren't taking her as seriously. They assumed that she would prefer her children to her work if she had to make choices. So she did bring a claim, and Judge Posner said this is gender discrimination.
I would like to say thank you to Dr. Spence, who joined us tonight from Washington, D.C. Dr. Spence, of course, with the National Association of Female Executives. Thanks so much for joining us tonight. I really appreciate it. Folks, I want to remind you, you can go to our website and watch any show that we have broadcast in the last 12 months. If you need the name of an attorney in about 3 dozen different areas of practice, go to our website, lawjournaltv.com. Call us toll-free, 888-78-LAW-TV, and get your law on demand. We also want to thank those people who made the film possible tonight, the BBC film Breaking the Glass Ceiling, produced by the BBC Active to order an educational non-theatric use in the U.S. Call them at 800-257-5126 or go to www.filmsmediagroup.com. I want to thank my group for joining us here tonight as well. Nancy Ezold, George Kanoupas, and Anthony Haller. Deborah Weinstein, thank you for joining us tonight. For all of us here at the American Law Journal, thanks for joining us. We'll see you next week. Good night now.
Tonight's American Law Journal has been made possible in part by Scheller, Ludwig & Scheller, one of the largest personal injury firms on the East Coast, winning large verdicts for their clients injured by Vioxx and other dangerous medicine, defective medical devices, consumer protection class action lawsuits, and product liability. Scheller, Ludwig & Scheller, 800-883-2299, and at Scheller.com.